Hi everyone, welcome to Lawpreneurz. Today is the first lecture of Indian Penal Code, and in today's lecture we will see some of the basic concepts which are necessary to study before you delve deep into the sections given under this code. Also, we will see how to interpret a section. Once the base is formed, then understanding any act becomes very easy. So let's go to Indian Penal Code and see the basics of it first. So you can see a PowerPoint presentation on your screen, and through this presentation we will understand the Indian Penal Code in a better way. So let's see. The first part whenever you study an act is the preamble. Now what is a preamble? Preamble basically tells that when was this act brought in and also to what extent does it apply. So if you see the preamble on your screen, it says that this act shall be called Indian Penal Code and shall extend to whole of India. Now this was drafted by the first Indian Law Commission of which Lord Macaulay was the chairman, and submitted to the Governor General in 1837. But then it only received the assent on 6th October 1860. That's why it's called Indian Penal Code 1860. Now you saw the first part of it, which it says that it applies. It applies to whole of India. Now before 2019. This was not applicable in Jammu and Kashmir. But under the Section 96 of Jammu and Kashmir Reorganization Act 2019, the Act was made applicable to whole of India. So now it applies to whole of the country. So this is the preamble. Now after studying the preamble, the next part that we have to see is Section 2 and Section 3. Now when we read about Section 2 and Section 3, it is around the concept that when a person is there on an Indian land, would he be punished in all circumstances? And if suppose somebody has committed an offense outside India, can he be tried in India or not? When we see the first section here, Section 2, it talks about punishment of offences committed within India. And it states that every person, if he is found on the soil of India and if he commits any offence here, he shall be liable in India under this code. But this is not complete what it says. Let's see in detail. And here we will see how to interpret a section. Now see here. Every person shall be liable, notice the word shall also, shall be liable to punishment under this code, not otherwise, for every act or omission contrary to the provisions thereof, of which he shall be guilty within India. Now, if you see the section, it says that every person. Now there's a reason why every person has been written here. Every person means that any person of any caste, any sex, any religion or nationality. It does not matter whether the person belongs to America, is from America, or is it from France. That means he can be an American, he can be a German or anyone. But if he commits an offense on the soil of India, he shall be liable in India. Also notice here that it's written for every act or omission. Now the reason why act has been given here and omission also has been given here is there is a reason behind it. You can be made liable for the offense of theft. You can be made liable for the offense of murder. But would you be also liable for something that you have omitted to do? Yes. Under the Indian Penal Code, suppose earlier wearing mask was not compulsory when you had a flu or in public spaces. Today also if you have a flu, it's not necessary, but in public spaces it has been made compulsory to wear mask. And if you omit to do that, you will be liable under section 188 of the Indian Penal Code. Or for example, there is a guard lifeguard who is near the swimming pool and does not save anyone who is drowning. So he has omitted to do something. Or for that matter, if you omit to follow the traffic rules. So an omission can also make you liable under this code. The whole crux of this particular section 2 is that any person of whatsoever creed, caste, sex, nationality, if he commits an offense on the land of India, he shall be liable. Okay. Now he cannot say that, look, I am an American and bigamy is not an offense in our country, or for matter, I am of so and so nationality and this is not an offense in my country. Remember, ignorantia lex non excusat. That means ignorance of law is not an excuse. Now there's a case here in front of your screen, and it's a Calcutta High Court passed judgment where there's a person who is of Baghdad and he comes to India and he is indicted for unnatural offense on the board on the ship. Now he says in Baghdad, unnatural sex is not per se defined as an offense. So why should I be made liable here? But such a defense was not accepted in the court of India, because when you are in other country, you should follow the law of that particular country. Definitely his defense would matter when deciding the amount of punishment, in mitigating the factor of punishment. But as such, he would not get an excuse from this particular offense that he has committed. And the court regarded it not being a legal defense. Now, this was about an offense when committed on land. The question arises, what if the offense is committed on high sea? What if the offense is committed on water? If an offense is committed in Godavari, obviously you will take it to the Godavari river, you will take it to the Nasik court. But till what stretch? So there was this case called Franconian case where a Britisher had committed some wrong on the high sea, and the question was, where should he be made liable, whether he could be made liable or not, but there was no law at that time. And Franconian case is the case behind the development of this particular law. And the law is that the territorial jurisdiction of a state extends into the sea as far as 12 miles. So from Mumbai to 12 miles, some offense is committed on the water, Mumbai court, all the courts in India would have jurisdiction to try that particular case. Now this is called maritime territory of a state. Now in India, this 12 mile was extended through a notification 30th September 1967. Why it was extended? Because earlier it used to be 3 miles. Now in a case called Emperor versus Kaistarama case, in this case there's a person who enters into the sea within the 3 miles of the coast and he removes the fishing stakes belonging to the complainant. In this case also it was held that the local criminal court had jurisdiction over the offenders and that the court applied to the case an offense amounted to mischief since it was within the territorial limit. Okay. Now, there are certain people who are exempted from civil and criminal proceedings and they have been given protection under Article 361 of the Constitution. Now, Article 361 states that certain categories of people would not be liable in case of any wrong they commit when they are on duty. So who are these people? President, governor of a state, foreign sovereigns, ambassadors, alien enemies, foreign army and warships. Now remember two things. When I said when they are on duty, the reason why I said when they are on duty is For example, if an alien enemy, foreign army, or a warship commits a crime while they are on duty, they will get this immunity. But they commit any offense in their personal capacity, then they will not be exempted from the civil or criminal proceeding that would be taken against them in the country. Okay, so it's only on the duty that they get this immunity. So remember Article 361. Now the next section of the IPC is Section 3 and Section 4. Section 3 talks about a situation where a person can be tried in India even if he has committed the offense outside. And Section 3 says that when he will be tried in India, it will be assumed that, or it will be deemed that he has committed the offense within India only. See Section 3. Any person liable by Indian law to be tried for an offense committed beyond India shall be dealt with according to the provisions of this code for any act committed beyond India in the same manner as if such an act had been committed in India. So if he has committed an offense beyond India, see this, beyond India, he will be treated in the same manner as if it was committed within India. But what are these situations? The situations you will find in Section 4. Section 4 talks about extension of the code to extraterritorial offences. Now the provisions of this code apply to any offence committed by a citizen of India in any place without and beyond India. So if he is a citizen of India and he commits any offence beyond India, he will be liable within or beyond. So there's an example here. Suppose there's an Indian citizen who goes to Uganda and he commits a murder there. If he is anytime found within India, he can be tried within India also. Second is any person on any ship or aircraft registered in India wherever it may be. So if a person who is on the Indian ship or aircraft and commits an offense, he will be liable or he can be tried in India. And the third is any person in any place without and beyond India committing offense targeting a computer resource located in India. Now this particular clause was added much later, keeping in mind the Information Technology Act. So if any person is sitting in, suppose in Pakistan and targeting the computer of India, if he is found in India, he can be made liable or he can be tried here in India also. This was about Section 3 and Section 4. So in short, you can say that Section 3 and 4 talks about extraterritorial operation of the code. But when we see Section 2, it talks about any offense that is committed on Indian soil. Okay. Now, let's take an example here. Suppose there is a person whose name is Rax and he is found on high seas on an Italian ship committing an offense. Later on, the ship enters India in Mumbai. Can he be tried in India? No, he cannot be tried in India. See, because both the conditions are not fulfilled. One condition is that he should be citizen of India. The second condition is that either it should have been a ship of India or the aircraft of India. None of the conditions are fulfilled. So in no circumstances, this person could have been tried in India. Second situation, suppose there are two people, one is American, one is Indian. The ship is of an American, it's an American ship. The person who has been injured in a fight is an Indian. Due to injury, he is suffering on the ship and later on the ship enters Mumbai. Now when the ship enters Mumbai and after some point of time he dies there, can the accused be tried here in India? No. A, he is not the citizen of India, he was an American citizen. Second, the ship was also American. So we cannot try him there. Okay, we have to look at the accused there. See, when we see a liability of a foreigner who is in no way connected to India, either as being a citizen of India or being a citizen of India or as a being on an Indian ship or aircraft, is not liable to be tried in Indian courts for an offence committed by him outside India. Therefore, jurisdiction in Indian Penal Code is one of the essential elements to hold that a person liable if he has committed an offence within India, where an Indian national has committed an offence outside India, should be held liable and need to be tried in Indian courts such that no one escapes from the punishment and proper action is done against the accused. Okay. Now, moving on to the basic part of the Indian Penal Code. The first definition that you should know when you start reading this particular act is Section 8 that defines gender. Now, wherever you see in the complete act the pronoun he, remember it is used for any person, whether that person is a male, female, or any other gender, that's the third gender also, it's used for all of them. Okay, so he basically denotes every gender here. Now, the next definition that you have to see here is man and woman. This is Section 10. Now, when Section 10 defines man, the section states that man is a male human being of any age, and woman is a female of any age. It's a simple section. So, any female of any age and any male of any age will be a female or male respectively. Now, the question here is, can a baby who is just 5 months or 6 months old be considered as woman so that a person, an accused, can be made liable for outraging the modesty of the woman? Or the question is, can modesty be attributed to a child who is just of 6 months or 5 months? So this was the case which was dealt with and discussed in State of Punjab versus Major Singh. In this case, there was an injury caused to the vagina of a child who is 7.5 months old, and it was a deliberate injury caused. Now, the question was whether the child's or the woman's modesty was outraged. The court, coming to a conclusion that yes, gave two reasons. One is the logical reason. This is that the essence of woman modesty is her sex. And even a female of a tender age from the birth possesses a modesty which is attributed to her sex. Second reason was given by them was Section 10 of the IPC, which states that a woman is a female of any age. That means if a female is of 5 years or 5 months or 2 months, 1 month, or even an old age woman of 100 years old, of an age of 100 years, all will be considered as women, and whenever something wrong has been done to them such that their modesty has been outraged, a section 354, that is outraging of the modesty of the woman, will be applied against the accused, and the accused shall be punished for outraging and intending to outrage whatever modesty that little victim possesses of or an old victim possesses of. Similarly, a very similar situation to like this was a case where a girl who was 6-year-old and Chandribai, who was also molested, and the same question had arisen there, that whether a 6-year-old child would hold that modesty or would have developed that sense of modesty. And similarly, the court said that whatever age it is, looking at Section 10 of the IPC, every female, whatever age, has that modesty, because we're talking about the attributes there. The next section is Section 9, which talks about number. So if you see a singular number given, that is man, you can take it as a plural. Wherever plural is given, it can be taken singular. So you have to read of them, both of them together. You have to read according to the context. Let's go to the next slide. Person. When you see the word person, it also includes company, it also includes association or body of persons, whether it is incorporated or not. It also includes idol, because idol, the god idol, ADOL, because idol is capable of holding a property. It also includes child, whether he is born or unborn. But remember, when we're talking about the corporate body, they cannot be made liable for murder, treason, perjury and rape, because this can only be committed by a human. Okay? Now see here. Now we have reached to the basics of the Indian Penal Code, where we have to understand the few definitions of it. The first word which comes to our mind when we see Indian Penal Code is crime. But the question is, what is a crime? See, we'll interpret this or we will read this particular section definition in such a way as if we are reading a section. See here, a crime can be said to be an act of omission or commission. This is one part. Contrary to law. This is another part. Tending to prejudice a community. This is the third part, which is important. So we break it in such a way. For which punishment can be inflicted. It talks about punishment here. As a result of judicial proceedings. Okay, the judicial proceedings are taken in the name of state. Now these are the important parts. So what we have done is we have taken a particular definition, thinking it of as a section, and then breaking it by pulling out the major elements out of it. Now a crime can be said to be an act of commission or omission. So we just saw, if you don't wear the mask, you omit to do something, you commit an offense. You murder someone, that's an act of a commission. So it can be omission and it can also be commission. And which is contrary to the law. It is very necessary to make it an offense. It should be contrary to the law. If it is not against law, it cannot be an offense. Right? Third point is that it prejudices the community. Now that is why it is said that crime and the criminal law can be defined as both legal and sociological. Why sociological? For example, suppose if I commit a murder in your society, tomorrow everyone in the society, your neighbors, the person living next to your neighbors, they all will be scared that what if similar incident takes place in our house? Or if I commit a robbery or theft in someone's house, definitely there will be a double latch that will be put in on every next door of every next house. This is why, because a fear has crept in. Okay, so it has not disturbed one particular person, but it brings a change or it brings a fear in the mind of the whole society. That is why it is said that a crime is something that causes prejudice to the whole community. That is why it is also called a sociological offense. Then the section says that for which punishment can be inflicted. If you do an offense, there's a punishment. How the punishment and everything is decided? It is decided through judicial proceedings in the name of state. So whenever you open a newspaper or anything, you would have seen that it's written state versus Nishcha, state versus so and so. What is the reason why it is written state versus so and so? Since I've just told you that it's a sociological offense, a state has to take action. So that is why all the criminal offenses that you will see would be mentioned as state versus so and so. Okay? Next concept is, or the next topic is crime and morality. The question is, what is the difference between crime and morality? See, they both are best friends. They both function in a similar way. The intention of a criminal wrong or a moral wrong is to keep the society intact, to protect the society. But you're only liable for a criminal wrong and you're not liable for a moral wrong. If I sneeze on your face, I might have done something wrong to you, but that's a moral wrong. But if it's a corona time period and I've been asked to wear a mask and all of it, and if I don't do that, that will be a criminal wrong. Similarly, if I'm sitting next to the pool and somebody is drowning and I don't save him, it's a moral wrong because there's a moral duty. Or if you are walking on the road and you're going to meet an accident and I can see that and I still don't try to save you, what have I done wrong? I have done a moral wrong. I had a moral duty to protect you. Or showing ingratitude or anything of that sort, that's a moral wrong. But what is liable here, what is punishable in the Indian Penal Code is a criminal law. Okay? Next we have to see few maxims here. See, mala in se and mala in prohibitia. When you see mala in se, it means that actions which are inherently wrong. For example, even if the law was not drafted, murder, theft, and all of them, they were wrong with itself, right? Okay, inherently they were wrong, but there were certain offenses that were made wrong by the law. For example, the traffic rules, for example, wearing of the mask in public. These are called mala in prohibitia. That means they were not inherently wrong but are made wrong because they are prohibited by law. Next important part of IPC is to understand general principles of it, which includes actus reus, mens rea, and general exceptions. You will see the part of general exceptions under section 6, okay, the mentioning of it. We'll see it later on, just consider that these are the exceptions. The important part here is actus reus and mens rea, which is the building block of it, which is the basic ingredient of it. Now, what is actus reus? See, actus reus is something that is a result of human conduct, such human conduct which law seeks to prevent. Actus means physical result of human conduct, or you can say a consequence of human conduct, and reus is something that is forbidden by law. To understand it, don't worry if you have not understood it, we'll see it in detail here. See, remember, actus reus is the consequence of a wrongful act. So let's see what is a wrongful act. Suppose you're standing on the top floor of a building, and if I push you, so there's an act, a physical conduct that has been done. The consequence of it is that you have died. Okay? And that is called actus reus because this is something that is forbidden by law, killing someone, murdering someone, and that's called actus reus. If I stab you, there's an act of stabbing and the consequence is that you've died. Right? If there is a penile penetration, then there's a penetration which has resulted in a rape. Okay? So these are the actus reus. Now the second part is the mens rea. Mens rea is your mental status, your mental situation, which talks about your guilty intention. Mens means state of mind and rea means guilty or liable to. So if I have a bad intention of killing you, all this is known as guilty intention. Now remember one thing. Actus reus and mens rea, they both have to be together to make it an offense. If they don't coexist together, it cannot be called an offense. Let's see 3 examples to understand this basic concept. And remember, it's the most important part of IPC. Suppose I have an intention of killing Mr. X and I plan every day to kill him. One day I think, okay, I'll get a poison. The other day I think, okay, I'll take a pistol and kill him. The third day I think, I'll just do something wrong in his car and so and so. So every day I'm having a lot of guilty intentions and I'm finding out the way to kill him. But this is what is happening. This is only the mental thinking that I'm doing. I'm forming an intention, right? This stage is not punishable. Mens rea itself alone is not punishable. Let's see the situation number 2. I and Mr. X, we all both go for a walk or we go for a rock climbing and I'm climbing and mistakenly something heavy from my pocket falls off and it falls on the head of Mr. X, due to which he goes into coma and he dies. Now here, this is situation number 2. I had no intention to kill him. It is only an accidental death that has occurred. Now, if there is no guilty intention, if there's only an act, do you think one should be made liable? No, because this is an accident. So, actus reus alone is also not punishable. It is only when actus reus and mens rea, they both are combined and brought in, that the offense is made. See situation number 3. I had an intention of killing Mr. X. I go to the market, procure poison, add it to the food, give the food to him. Mr. X consumes that food and he dies. So I intended and then I actually did it. So there's an act and there's a mens rea and therefore there is an offense, and I will be liable for the act of murder, for committing murder. Whenever you see a section in IPC, first of all, find out, locate where is the intention. The actus reus and mens rea should be there. See this this Venn diagram also. The highlighted, the mid part, the common part is the offense. The next part is where you see some of the important definitions. Now, culpability and liability, they both mean somebody who is blameworthy. For some, culpability means now you'll be punished. Liability means there will be a legal liability, and there's a liability to go through a punishment. When I say illegal and legally bound to do, this has also been defined under IPC. Illegal means something that you're doing that has been prohibited by the law, or something that gives a ground for taking an action against you. But what is the meaning of legally bound to do? It means something that you cannot omit. You're legally bound to follow the traffic rules. This is called legally bound to do. The next important definition is injury. Now remember, injury is a very important part, and you will find it in a lot of sections. But when we read this particular section, we have to learn to break it into parts. It denotes any harm. So see, the harm is the first. Whatever illegally. Illegally means something that is prohibited, right? We've seen in the previous definition. Cause to any person. It can be caused to any person. Okay, it can male, female, any caste, anyone. And where? In body, in mind, in reputation, and property. Okay. I'll just highlight mind, body, and reputation also. Okay, probably this color is not visible. I'll just change the color. Yeah. So mind, body, and reputation. And when you see the word caused also here, caused means the means that you have adopted to cause this injury. So injury is basically a harm which is caused to any person. How is it caused to body? By murder. Mind, cruelty, causing torture of the mind or doing anything of that sort. Then you have reputation. Reputation is when you defamation, when you harm whatever perspective of you I have in my mind is the reputation that you hold. And if I cause injury to that reputation, if I cause harm to that reputation, I've caused an injury to you. Property. Theft or anything, for that matter, the example mentioned here is that crushing somebody's watch by the shoe. Next important definition here is voluntarily. Now, what is the meaning of voluntarily? Voluntarily shows your mental state. If I say that you have done an act voluntarily, that means either you had intended to do it, or you had knowledge, or you have the reason to believe. See here, a person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it. It says whereby he intended to cause it, or by means at the time of employing that means, when he was using that means, he knew. That means he had knowledge about it, or he had the reason to believe. So for example, if I want to kill you, I had the intention, so I've done it voluntarily. If I know that I get drunk and I can kill someone, and I know drinking is not something that is allowed, or I might act in some behavior which is not right, so that means I had a knowledge about it. Or if I am driving on a busy street in a very fast pace without a headlight, I had the knowledge that somebody might die. It does not matter whether I had the intention or not. A little lesser level to this is reason to believe. Reason to believe is also a lesser degree of knowledge about it, a lesser degree of mental knowledge, mental status, where the court finds out if you had something to believe, acha, this can happen. Now, for example, there's a house which you have burnt it, saying that I just wanted to cause harm to the property and I had no intention of killing anyone. Now, for the fact that you know that there were people, it's an inhabited society where people generally live. So that means you had the knowledge, or you had the reason to believe that there might be somebody in the house who can be injured because of the act of, of yours of burning that particular house. Now, how do we get to know about this intention, knowledge whenever a case comes in front? So it's gathered from the surrounding circumstances, that why would he have done that, what was the conduct before it, what was the conduct behind, after it. So this is the way we gather this particular state of mind. The last part of today's class is intention. Now, intention, as you know, is one of the mental state of it. But the problem comes when you have to find out, or when you have to figure out basically that what is the difference between intention and motive. Remember, intention and motive, the difference between two of them is a very confusing part, and most of the people tend to make a mistake there. See, intention means to have in mind a fixed purpose to reach a desired objective. So something that you're doing consciously. It's a purpose or design. It's a design to cause a particular result. But why have you done that particular thing? That is called motive. So for example, suppose I have a brother, or suppose Mr. X has a brother, and he wants to inherit the whole property, but he knows that he cannot inherit the whole property till his brother is also alive. So the only way to get hold of all the property after their parents is to kill the brother. So he kills the brother. Now the intention here is, the consciously done thing is what? Or the design is to kill him. For achieving what? For achieving a particular result. And what is that result is? Inheriting the property. So why this has been done is the motive. Now remember another thing. If you find out in a case a motive or not, it is not something that is the sine qua non. That means it's not the most essential thing here. What is essential when an offense is committed is the intention. You have to find out the mens rea. There are chances that in the cases where the judges might not be able to locate the motive there, that does not mean that the offense is not committed. Also, there are situations where the motive is good, but the intention is bad. For example, if you have so many animals tied up in your farm and they're just closely kept to each other, maybe you're milching them or you're doing whatever. But I as a neighbor don't like it because I'm too compassionate towards animal. And one day I slyly enter into your farm and just free these cows, these animals, dogs and all those animals that are tied in your farm with the motive of giving them free life. But what have I done? I have caused theft. So the intention here is theft for the purpose of, what is the result? For freeing the animal. So you see, here though my motive is good, still I will not be excused. Okay, so what matters in a case is the intention and not the motive. Motive helps the court definitely to find and reach to the right conclusion. So when you read a case, when you read a subject, you should try to link it with other subject also. So when we study motive here, remember motive is mentioned under section 8 of the Indian Evidence Act, where it becomes a relevant fact and helps the court to decide a case, as in why this particular case has occurred and who is the person behind it. Okay, so the motive becomes relevant there. Now apart from that, in today's class, you just need to know, there are more definitions to it, but we will study in the next class. You should know the difference between the motive and the intention. See here, motive is something which prompts a man to form an intention. It's an emotion which impels a man to do a particular thing. So if A killed B with a knife to inherit the property, inheriting is the motive and killing the was the intention. Okay, so this is all that we're going to study, we covered in the first lecture. Some base of it with the major bases as actus reus and mens rea. We studied the preamble as in it applies to whole of India. It came into being in 1860. Then you have to also remember that section 2 and section 3 and 4, where you see when the offense is committed in India and suppose it is committed outside India, and in which situations it can be tried within India. You should know the definition of gender, man and woman. Okay, so yeah, and voluntarily, uh, injury, these are the important definitions. You should understand the base of it. Try to make as many examples you can when you read any concept. For example, if you studied about actus reus and mens rea here, and I have given you 2 3 examples, try to make examples around your own surrounding. Use your own family members, kill them, or make them victim of anything, or make them a hero of anything. Just make some cases or make them criminal. Okay, so this is how you will connect to the subject. So for now, for the first lecture, this is it. We will continue in lecture number 2, where we will be seeing few more definitions, few more basics of Indian Penal Code, and slowly we will be moving to our first offense. Okay, thank you so much.